Well, Fred, we've been talking a number of things in these segments on the BCO about, following good order, that the BCO can be our friend, not our enemy, if we use it well. And one area that you and I've seen the BCO maybe not used like it could is just the proper order and form if we have to get to that place of doing judicial process. So, what is judicial process? Explain that term, and then we'll talk about the steps.
Well, judicial process is, I think, one of the areas where it's most important to follow the order, because almost by definition, judicial process is adversarial. And so if you make a mistake, that can cause problems and delays because the other party is going to try to take advantage of that mistake, whether it's a mistake in the process or not submitting to a trial or something like that. So when we talk about judicial process, previously we talked about the difference between sort of pastoral order and the judicial aspect of elders, teaching and ruling elders. And judicial process is a formal process. It's when we move from the pastoral to the formal judicial. It's when we put our hats on as judges. And so that makes it all the more important for us to follow the various rules and guidelines, because they're spelled out in great detail. And so we can't say, we didn't know how far in advance we had to send that letter. We didn't know that we had to have evidence. We didn't know when we could hold a trial, because it's all laid out in the Book of Church Order.
Yeah, well, that's good. Now, if we had already spoken in another segment about the investigation, and we know that the judicial process does not include the investigation. That the investigation is the court, whether at the session level or the prostrate level, doing an investigation to see if there's sufficient evidence that raises a strong presumption of guilt. If the court determines that, then it institutes process. Now you have begun the official judicial process, and then you the court appoints a prosecutor, and then that prosecutor, and working with the court, develops the indictment. Indictment basically contains at least two parts: the statement of what the charge is or charges are, and then the specifications under each one.
And I think it's important for us to remember that while maybe the most common way to get to process is through a formal investigation, a 31-2 investigation, that's not the only way. And so either a court can do a 31-2 investigation, which results in process, or there can be charges filed by a private individual that starts the formal process, or the court can, on its own initiative, for the honor of religion, institute process by filing charges against an accused. Exactly. And all of those ways start the formality of process and the rights of defendants. You might think of it this way. We all have grown up being used to now knowing that police, whenever they arrest someone, have to read them their rights. Some of us know them by Miranda rights, but we can all probably recite them from memory because we've seen it in every police show since the 70s. And so the point there is the police are starting a formal action. They're not just talking to somebody on the street corner. They're not just interviewing someone at their house. They are taking formal authoritative action by arresting someone. And so in a similar way, as soon as a court begins process, everyone should be aware that the accused has rights and that the court has responsibilities, and it has to follow the guidelines laid out in the book.
Exactly. And so it has to happen, because we can say in this case, because the guidelines in the book are quite precise, that including the indictment. So, by the way, just let's be honest that people in the church, when they hear the word indictment in the term of a church court, it gets a little, it sort of grates at them. But that's the whole reason why it's so important that we follow the thing. So even though that's sort of a gritty sandpaper kind of thing, at least.
But it is a necessary thing. Necessary. So as much as we might get upset emotionally about the word indictment, we wouldn't think much of a church that simply turned a blind eye to blatant sin.
Exactly. So let's get over that hurdle, because that's just something that if people, especially if you haven't done it before, that sounds so new. All right. The indictment includes the statement of a charge, and the charge statement is very generic, like maybe violating one of the commandments or violating a particular part of the rules of the confession or something like that. Okay, so there's the charge. It's generic. And what demonstrates it then are the second level known as specifications, the specifics.
Right.
When did the thing happen? Who did it? When? How was it done? Who were the witnesses? And basically, as much as you can, the court should outline why this charge and how these specifications support those charges that are put forward.
And I think it's important here that courts need to use a good faith effort to put this together. And so, for example, a court shouldn't give no specifications. But a court also doesn't need to worry about if they found every single possible instance or if they've listed every possible witness. It's not as if a witness isn't on that list, they can't testify. That's not what the book is saying. But what the book is saying here is that you need to give these specifics so that the accused can present a defense. Because if someone is alleged to have lied to someone, for example, on August 8th, and they produce evidence that they were out of state on August 8th and couldn't have possibly done this, that would be relevant. But if they don't know when they're accused of talking to a certain person or in what context, for example, that lie would have been told, they can't raise a defense.
Yeah, exactly. And in fact, BCO 32-5 makes that point, that as much as possible, the court, it says, should have the specifications in the indictment in order that the accused can prepare a proper defense. So that's an important criteria. So having no specifications would be out of order, or no, but it's not requiring that you have every jot and tittle either. So and so your point, I think, is very well taken, that it needs to be enough, though, that I know, as if I'm the accused, where the court is going, and that will be the way in which the prosecutor will then present his case.
And again, I don't think we should try and raise difficulties for ourselves in this. So, for example, some people think, because of their familiarity with trials, again, in the news or in movies or in television shows, that if you're going to have a trial, this is going to be, a month-long affair, and every night you're going to have and depose all kinds of witnesses, and it's going to stop the church, and the pastor won't be able to preach. And that doesn't necessarily need to be the case. The trial could be an hour long.
That's right.
It could be done in one evening. And so we shouldn't let misapprehension stop us from doing the right thing. We need to follow along, with the rules, because again, as we've said in a previous segment, the failure to follow the rules really just creates more work.
That's right. Extends the time framework. Yeah. So, so once the court has strong presumption of guilt, they institute process, they have appointed a prosecutor, they now have the indictment drafted, as we've just spoken about, then they have to get the information to the person who's accused. And what are the steps for that? What happens next?
Well, they need to send it to them.
Right.
And they need to send it to them in a way that is verifiable. So preferred way to do this is by some form of registered or messenger delivery mail where you get a receipt, because part of the requirement here is to know that the accused has received this, what we call a citation, kind of like a summons, because if they don't respond, then you have to send a second citation to them. Basically, we really mean it. You have to come and be a part of this process. And if you can't verify that you've sent this, then you can't take the steps that are necessary. You're kind of caught in a no man's land. But if you send it via like a Federal Express or a certified mail or something where you get a receipt.
Or you can hand it in person.
And then, of course,
and sign off.
Having a sign or witnesses to see it handed in person. The idea is it needs to be verifiable. And then this way, if the accused doesn't submit to a trial, doesn't show up, you have proof. And this is very important because in my experience, the vast majority of discipline cases, defendants do not show up for a trial, will not submit to a trial, do not want to meet with the court. And our modern church culture allows this. People just move on to another church, and that new church doesn't ask questions about their previous membership, doesn't ask about discipline. And what's very sad is that oftentimes PCA churches won't. So maybe this is an aside, but if you are a member of a session especially, and someone comes and asks to join your church, and you give a membership interview for them, and you take their testimony of faith in Christ, one of the important steps you should do is to ask them about their church background. Where did they come from? Where were they previous members? And it's doubly important to ask, where can we send this transfer request to make sure that good order is upheld, but also if there's an instance in which someone's not telling you everything that's occurred, then when you speak to their previous church, you can be brought up to date on what's going on.
Exactly. Going back to the indictment then, and by those points that you just made are absolutely excellent, because if we don't follow them, they harm the process. That the book requires that the citation or the summons be sent, and you have to give the person at least 10 days to answer that, and they to appear to enter a plea. And that's all that happens at the next meeting, is they enter a plea, either they're guilty or not guilty. So
you don't expect to come to that first meeting, drop all your evidence, and try to, bull's rush on that. It really is a very brief meeting.
Very brief, and that's all you need to do. And then, if the plea is not guilty, then you move to set up a date for trial, and you usually negotiate that because you want to give enough time for defense to prepare, the defense and the prosecution also to prepare to prosecute. And so once that is set, then you move to the next main step would be trial, unless there are some questions between the time the pleading not guilty to the trial. There's some questions that you have to present to the court to get clarification, and that can happen as well.
And I think the point that you made there is important about trying to set up a time frame that is reasonable and workable. It's to no advantage to try to take advantage of the other party by rushing the trial or holding it at an inopportune time. All you're really doing is giving the opportunity to appeal. So, for example, you would not want to set the date for a trial on a date that you know that the accused is going to be out of the country and won't be able to be there because they have a business arrangement they can't change. There's no need to insist, because all you've done is raise a possible appeal for the court being high-handed with the accused and not allowing him to present his own defense.
Yeah. So, and the book again says there's a certain period of time after that plea before you can do it anyway. So you do have that, but usually that's a very short period. So most times I've seen, in my experience, that they need more time to prepare the way. So now, if the person, the accused, doesn't heed that first citation, so it's sent out along with the copy of the indictment. The court meets and at the appointed time, place, and the person doesn't show. What are they to do next?
Well, they have to send another citation, a second citation. You can't just say, oh, they're not going to show up. And this is often the case. So far more often than usual, people who are accused of offenses simply ignore what the court has sent. They'll say, well, I'm done with that church anyway, or they don't know what they're doing anyway, or I've moved on to another church. And so that makes it all the more important for the church court to follow the rules and the guidelines, which say not only must you cite them once, but you must cite them a second time. Now, this makes sense because they could have forgotten about it, or something could have got lost, or there could be any number of reasons. But by following up with a second citation, you're making very sure that they know that this is serious and they have to heed this.
Well, in fact, the second citation is to have the warning. Failure to heed this second citation can lead to the charge of contumacy. Now, that sounds like a really dangerous word, and it is. It means that you're not heeding, you're in contempt of court.
That's right.
And therefore, you're not heeding a lawful citation. And therefore, if that happens, you don't heed this second one, then you will be guilty of contumacy, and then that's BCO 32.6, and that takes you over to BCO 33.2, for the court to say, this is what the book says we have to do.
And this word contumacy is a funny kind of word. People just have difficulty pronouncing it. You're found contumacious, or you are found guilty of contumacy. But it really is an important part of the process. It upholds two biblical principles. The first is that an accused can't simply ignore church authorities. That goes back to our membership vows, in which we agree to submit to the authority of the church. And so we can't just ignore what they're doing. But on the other side of the equation, there's no such thing as a trial in absentia. You can't pretend a defendant is sitting in a chair when he's not and find them guilty of an offense when they can't contribute to their own defense. And so what do? You're kind of caught in the middle here. Well, contumacy covers this, because what it says is that you're guilty of not submitting to your vows, of not heeding that. And until you do, you can be censured.
Exactly, and it's specifically told what that means. So to pick up the matter then later on requires that first you repent of that contumacy, get that all fixed. Then those charges that have been sort of put on the back burner are now brought forward again, and so that you can go forward with trial of that offense.
Right.
You can pick it up. And if someone lingers in contumacy and refuses to deal with it, the court can move forward to excommunication, which is really a serious matter. You don't do that right away. You're basically suspended from the Lord's Supper and that kind of thing. But later on, it could lead to that, and you don't want that. So if you're a member and you've been charged, even if you don't feel it was done correctly, go through the process, because otherwise it'll wind up putting you in an even worse situation. You've been saying correctly on this thing in our various segments, it's better to follow the rules than to put yourself through a longer period of time, exasperate yourself and everybody else. So deal with it correctly. It's much better in the long run.
And this is true of all of life, right? If I have a drip in my bathroom from the plumbing, and I just pretend it's not there, it's not going to get better. What's going to happen? It's going to get worse.
Yes.
And this is how it is with discipline. If the accused just ignores the court, that's not going to make that go away. They're not going to be in any better position. They're going to actually have more difficulties to overcome. Far better to heed the admonition, to, if you're innocent of the charges, to present your defense and to be vindicated in that sense, than simply to wish it away.
Right. Well, in another segment, we'll talk about just do the trial itself. If, assuming the accused says, okay, I'm ready to go to trial, what are the steps? And we'll take that up another time.
Very good.